Oral argument in our cause number CV130533 in the matter of Arthur J. O'Connor versus the Arizona State Board of Medical Examiners. Each side will have 20 minutes to argue. The appellant, if you would like to save time for rebuttal, we will let you manage. But as you come forward, you'll see the clock, and we will try to help you, but it's your clock. We are recording this information. There's also a videotape in here, so if you want to see that later on, apparently it'll be on YouTube, and you get to put the music to it if you want. So we have read the briefs in this matter. We have conferenced the case. We have an understanding of what it is. And with that in mind, make sure you also that as you come forward, please identify yourself and your client so that if we do listen to the audio tape, which will be available quickly, we won't have any questions, even though we know your voice is different, Ms. Roche. With that in mind, Mr. Jench.
Thank you, Your Honor. My name is Dan Yonch. I'm here on behalf of appellant Arthur O'Connor. Dr. O'Connor, could you stand up, please, so they can see you? And I would like to try to reserve 5 to 6 minutes of time for rebuttal. We are here because we feel that the Arizona Medical Board, a state agency, has violated Dr. O'Connor's rights to a full, fair, and impartial hearing, to his constitutional rights of due process and the taking of his property interest, his allopathic license, and particularly in the failure of the ALJ and the Arizona Medical Board in failing to articulate resolution of a tremendous amount of conflicting testimony and failing to do so with any sufficient specificity to permit an appellate court to review what went on in terms of the assessment and determinations by both the ALJ and then, of course, the Arizona Medical Board. I want to assure this court we are not asking and not expecting this court to substitute itself as the finder of fact. But we fully expect this tribunal to function as the overseer in protecting the rights of Dr. O'Connor and ensuring that a fair process was made available to him, or hopefully in the future will be made available to him. The Arizona Medical Board forwarded this matter for a formal hearing to the OAH, Office of Administrative Hearings, essentially to take evidence regarding 3 patient complaints of inappropriate touching and sexual abuse, as well as the board's contention that Dr. O'Connor lied to the board with intent to mislead about other patients' complaints of a similar nature. This hearing was held in September 2011. The matter went back to the Arizona Medical Board, where it adopted and ratified the findings, conclusions, and recommendation for revocation of ALJ Tully.
What are your specific complaints? You started the presentation with constitutional or due process violations.
Right.
And which ones are you articulating specifically that weren't done during the administrative process, sir?
Well, specifically the denial of due process regarding his property interest that was taken as a result.
Well, it's the taking as a result, but what happened that is the denial, since there was notice and the opportunity to be heard?
Well, I have a hard time answering that in 1 or 2 sentences, but if you give me the opportunity, I'm about to lay out the various things that we think were very egregious in that regard. So I would like to provide insight for this court in assessing the actions and the conduct of Dr. Tully, or ALJ Tully, as well as the medical board. First, I'd like to talk about the specific individual complainants, the evidence and the testimony was given, and the failures during the process that occurred that I contend denied him his due process. First of all, the complaint of patient MT goes back to 2003, though it did not become a board complaint until January of 2011. By way of brief history, Dr. O'Connor saw the patient in the hospital in January 2003 and performed a laparoscopic cholecystectomy. In 2011, when the patient was interviewed by the board staff, she said she was incensed at Dr. O'Connor for pulling her panties down too far at the follow-up office visit on January 15th, said she would never let him attend to her again. However, 10 days later, January 25th, she presented to the ER and she requested that Dr. O'Connor be summoned, and he attended to her. We then fast forward to October of 2003, when patient MT is again in the hospital and Dr. O'Connor was consulted to see her. On that first visit in the hospital, in the course of giving medical history leading up to the hospitalization, the patient indicated she had undergone a breast augmentation in the past few months and made a statement that the doctor interpreted as a request for his assessment. He did a brief breast exam over her shirt in the presence of her husband. Neither she or the husband made any objection. However, after he left the room, the patient became angry with her husband for allowing the touching and made a complaint to the nurse. Patient MT testified under oath that Dr. O'Connor was thereafter not allowed in her room. She could not explain the fact that the records demonstrate Dr. O'Connor saw her on the 2 successive days without objection. I point this out because ALJ Tully in his findings with regard to the complaint of patient JPP pointed out her testimony was inconsistent and lacked credibility when she was confused and could not reconcile the timing of removal of her nasogastric tube when the medical record says it was a couple of days different.
Sir, we have carefully reviewed the record here, and I understand the point you're making, but it was up to the board to resolve the conflicts in the evidence, and I recognize there were conflicts in this evidence, but you have said in your brief and also to us today that it's not up to us to basically be a new fact finder, and that is not our role. Our role is to deal with legal errors, and everything you've said to date so far just reflects conflicts or inconsistencies or questions about the evidence and the testimony, and that's what the board does.
Well, okay, but I have not finished my presentation,
No,
Judge, and here's
I understand
my
that, but Judge Portley asked you a question about what are the precise due process violations alleged here, and your time is running, and I'd like to get and focused on those due process violations.
Well, I understand, and I'm trying to get to that, but I want to make sure the record is clear. I guess one of the major things is that when you look at the findings of fact by Judge Tully, and of course it goes over to the medical board, they don't talk about that stuff. They just either rubber stamp it or reject it. When we went over there after the hearing, they gave me 5 minutes to address the board. They did not want to hear about whether it was a fair hearing or how things were done. Here's my problem. The court in Post v. Industrial Commission says when there is conflicting testimony, and that to me particularly applies in a case like this where it's a swearing contest. It's a he said, she said situation. There isn't a tremendous amount of extraneous evidence. It's these two parties, the complainant and the respondent doctor, and they have to decide who was more credible. Well, and this reviewing court, nor anyone else, can assess whether ALJ Tully and then the board did an appropriate and adequate job under the constraints of Fifth Amendment due process if they don't discuss it. When you look at JPP, and I pointed this out in the brief, he did a great job there. He did the job the way he should have done it. I think he had something like 18 or 19 findings of fact. Most of them were conflicting evidence that we presented. And what did he find? He found that she was not at all credible. Therefore, he found in Dr. O'Connor's favor on that. What about the other two, patient MT and patient TM? He has 5 or 6 findings of fact as to each of them. I was in the process of pointing out various conflicting evidence to which ALJ Tully and then later the board makes no reference whatsoever. They don't tell us why this.
Sir,
what?
the case law that both sides have cited on this and especially the post case, don't require, as far as I know, there's no case law that requires an ALJ, and more importantly, the board, which is what is at issue here, to make a finding on every single contested issue or controversy about the facts. I don't know of any case law that says that. And here, as I look at the ALJ's findings and then what the board decided and their adoption, it seems like they made more than enough findings to determine that, regarding the testimony of the two complainants. What more would you have wanted them, what more should the board have said?
Analytical analysis of the evidence, and particularly the conflicting evidence. As I pointed out, he did that appropriately with regard to patient JPP. What did he do with regard to the other two? He simply took the allegations in the complaint and transposed them into his findings of fact. And I'm about to point out all of the things that should have brought into question seriously the credibility of those complainants, and yet he never addressed it. So we don't know whether he considered it, whether he made up his mind at the outset as to what he was going to find. We simply don't know. Therefore, a reviewing court cannot know. That was really the point of Post, that enough has to be set forth so a reviewing court can tell. Now, Post is not on all fours with us here. That was a petitioner seeking to get a statutory remedy of reopening his workers' comp claim. This is loss of a very significant protected constitutional right in this professional license. Therefore, there has to be a significant level of scrutiny by the finder of fact. And like I say, you're not the finder of fact, but you certainly need to scrutinize whether the finder of fact did his job. And I was about to point out all in the many ways where he failed to do it.
So you would essentially have us, at best, remand the matter back to the ALJ, either for a new hearing or for him to flush out the findings of fact, which, at least as I think I understand them, suggests that he's resolved the conflict, but against Dr. O'Connor.
Well, we don't know that he resolved any conflicts. I mean, he doesn't tell us that. He tells us as to JPP, he found her lacking in credibility. As to the other two, he says nothing about their credibility. Let me point out...
Isn't it just absolutely clear he found that they were credible, given the findings that he made and the findings that the board made, and then the end result? Isn't it just absolutely clear that the board found that they were credible?
No, it's not clear at all.
You think that the board didn't make any finding that they were credible based on their determination of the contested issues and their resolution and sanction entered here?
Well, there was certainly no discussion of that at the public board hearing.
Does there have to be? Do you have a case that says they have to absolutely discuss that at a public hearing?
Well, you asked me, Your Honor, didn't they do this? I'm saying, well, if they did, they certainly didn't tell the public they did it.
Is there a case that you have that you can cite to me that says the board needs to, at the public hearing, make credibility findings?
No, I didn't say that, and I don't suggest that, but I think due process considerations are extremely important here, and I don't think I should need a specific case going to that detail when I think we all understand the significance of due process and when there's a protected constitutional right. Let me point out a couple of things. You know, the board says there were 5 complainants here, and they consider that to be a pattern of conduct. Well, I don't know if you gleaned this from reading this, but in one fashion or another, all 5 of those complaints were evaluated and dealt with in some fashion. And guess what? Dr. O'Connor was exonerated in all 5. The first 2, MT and CW, went to peer review at the hospital. They found he met the standard of care. Therefore, they took no action. They did not report it to the medical board. Patient DH, 2007. I represented him on that one. That went to a full board investigation. The board concluded there was insufficient evidence. The county attorney declined to prosecute. There was a formal dismissal. And by the way, point out on page 7 of the findings of fact, ALJ Tully in a footnote is totally confused about DH. Sort of says, well, I wonder whatever happened. Was the doctor disciplined over this? Heck no. That was dismissed. It was a formal dismissal. Dr. O'Connor was exonerated. As to patient TM, that complaint came about April, well, it was a formal complaint as of July of 2010. Took the board 18 days, the board staff, to conclude there was insufficient evidence. They administratively closed it due to that fact, and they were only waiting on the county attorney to decide on prosecution. He later declined to prosecute. There was no mention of any of this by ALJ Tully, and at the time of the formal hearing, the board had conducted not one additional bit of investigation on patient TM, and yet the state's attorney contended that a couple of months later, when the complaint of patient JPP came along, that constituted corroboration of the validity of patient TM's allegation. Well, and we know that at the formal hearing, he evaluated and considered the testimony of JPP, found her to be totally lacking in credibility. So you've got 5 complaints that the board said is a pattern of conduct. We say, yeah, it's a pattern. It's a pattern of unsubstantiated false complaints. This is exactly the kind of thing under due process that a hearing officer in the board should be addressing. How can this be? And yet he just puts in 4 or 5 findings as to MT and TM taken from the complaint, and that's it. Thank you. I will save the rest of my time.
Okay, thank you.
Good morning. May it please the court, my name is Ann Froge, Assistant Attorney General, appearing on behalf of the Arizona Medical Board. You've heard from Dr. O'Connor that he did not receive a full, fair, and impartial hearing in this matter. However, the record on review demonstrates that he did. The record demonstrates that as required by Webb versus State Board of Medical Examiners, Dr. O'Connor received notice and an opportunity to be heard at a meaningful time and in a meaningful manner. In fact, he had a full evidentiary hearing where many witnesses were called. His attorney was able to cross-examine the state's exhibits. Many exhibits were received into evidence, and there were no elements of due process missing in this case. The state did not fail, as Dr. O'Connor has alleged, to meet the legal requirements set forth in Post versus Industrial Commission. That case can be distinguished from this case. In fact, that case is a situation where there were 2 conflicting experts, and the administrative law judge failed to set forth any conclusions applying law to fact. And in fact, there were no findings at all regarding causation.
Well, it seems that what Mr. Yunch has just told us is that although individual issues had been raised earlier and resolved, then they were resurrected as if there was a basis to rehear. And he just outlined 2 were peer-reviewed, he was found, and there was insufficient evidence, and 1 in 2007, the county attorney declined to prosecute 2 of them, and then JPP, as he's pointed out, was found to be incredible. Does a record reflect, and I think I've reviewed most of it, that the ALJ and then the board essentially just missed it?
Your Honor, I believe that the record reflects that there was substantial evidence on the findings that are delineated in the ALJ and ultimately the board's decision. There were other matters and other things that went on over the course of the years, but I believe those findings very clearly show what the judge found. And as far as patient DH or CW, that information was not alleged for the truth of the matter or to show that whether or not there was misconduct regarding those patients, only that with regard to CW and also MT, that Dr. O'Connor failed to disclose that those allegations had been made against him. And so when you look at Judge Tully's findings and ultimately the board's findings, it's very implicit in those findings what the judge resolved. The findings track the testimony and the evidence, and as Mr. Yonch stated in his brief, he stated that the judge did a marvelous job of resolving the conflicts in the evidence regarding JPP, finding that she was not credible. And that finding, if you look at the evidence in this case, the finding had to do with the fact that she was partially that she was on some medication that may have caused her testimony to not rise to the level of credibility. However, we submit that the judge and ultimately the board did the same thing with regard to the evidence as to TM and MT. Those findings track the testimony. It's implicit that the judge believed what MT and TM testified to and other evidence that was offered in the case. And the ALJ need not rehash everything that happened during the hearing. The transcript and the record does that. But I think what happens is the ALJ's decision must contain a concise explanation of the reasons supporting the decision. And in this case, the findings do exactly that. The Post case distinguishes another case called Pierce. And I would submit to this court that this case is a Pierce situation and not Post. In Pierce, the court was able to ascertain from the record that the findings supported the conclusions, and a reviewing court was able to look and see exactly what the conclusions were based upon. And in this case, I believe that the findings are very clear as to what Judge Tully found and ultimately the board. Also, again, the board does not just rubber stamp the findings. The board reviews the record and adopts those findings. Then the Superior Court in the judicial review action did the same thing, and I think that's significant here. There was substantial evidence to support the findings. And even if there's evidence that would support another finding, pursuant to the Rittling case, it's up to the trier of fact to find that there was substantial evidence to support the findings that are made.
What about the board's consideration of the Sante report?
Oh, the board's consideration of the Sante report, the findings in this case, even though Judge Tully at some point came in the hearing and said he was admitting the Sante report for all purposes, the findings only reflect that it was considered for a limited purpose. The findings that were made reflect the purpose for which the state offered that report, to show that Dr. O'Connor did not disclose the allegations that were made against him by patients.
Findings basically 51, 52. Excuse me, I'm referring to the ALJ, and I should be referring to the board. But,
The board's findings.
Yeah, the board's findings, yeah. That during the assessment, when asked, he falsely disclosed that only 3 complaints had been made against him for inappropriate touching. That's what you're saying?
That's correct, Your Honor. And so when you look at those findings, it's clear that the use of that report was for the purpose for which it was originally offered by the state.
But that, forgive me for lack of a better term, is that not a bait and switch, but he says, okay, I'm going to allow it in for all purposes, and then doesn't that put Dr. O'Connor at a disadvantage because he doesn't exactly know, well, how is this going to be used against me? Isn't that one of the points here?
Well, the Sante report had been disclosed long ago, and Dr. O'Connor, in fact, brought in this case, a polygraph expert of his own, and he actually had an opportunity to address the report. The hearing was not concluded. I believe he did have an opportunity to address the report, although, again, in the end, the judge only his findings are only regarding the failure to disclose the two other complaints. So I believe that there's no showing of any prejudice here by that report based upon the findings of the administrative law judge. If the administrative law judge and the board had made other findings based upon that report, that may have been another issue, but in fact, he did not.
What about Dr. O'Connor's argument that he was not able to really respond or counter the Sante report because he was not provided with basically the backup information that the authors of the report had utilized or prepared in the course of the assessment?
Again, in this case, the state was not offering the report for any other purpose other than to show that he didn't disclose the other patient complaints. And the state complied with its statutory disclosure duty in disclosing the report, disclosing results of any evaluations or tests. And so in this particular situation, it was irrelevant because it wasn't to be used for, the state wasn't trying to use that report for any other purpose.
I want to make sure I'm clear on the record. It is my understanding from looking at the record that the board did not have the files or the raw data as they're characterized in the opening brief. The backup material that gave rise that the Sante authors may have prepared, it did not have that data. Is that correct?
That is correct, Your Honor. And the state disclosed what it did have. Mm-hmm. And
so they disclosed everything they had, and they said, we don't have what you've been asking for.
That's correct. Okay. And so, to conclude, in this case, again, Dr. O'Connor had a notice of the allegations against him, opportunity to be heard in a meaningful manner at a meaningful time. He had all elements of due process in this case, and the findings of fact, conclusions of law and order that were entered were based upon substantial evidence. And the state is requesting at this time that that order be upheld. I'm happy to answer any other questions.
Other than the board having a public hearing to address an argument after they had the opportunity to review, and this I haven't researched fully yet, is there an opportunity for Dr. O'Connor or others to complain about the ALJ's findings of fact before the board makes its final determination?
Yes.
Before the petition for rehearing or review to the board, at least.
Your Honor, the process is, there's a board meeting where the board considers the ALJ's findings and, in fact, adopts those findings and enters its own order, which happened here. Then Dr. O'Connor had the opportunity to request the rehearing or review by the board. So it again went to another board meeting where the board could determine if there were any legal errors or reasons to rehear or review this particular case, and they did not do so. And then at that point, it was appealed to Superior Court.
So the record is that after the board issued its decision, Dr. O'Connor did not then seek either a review or a rehearing and bring to the board's attention the alleged inadequacies of the findings or other errors that he has alleged the board committed. That's correct? There was no request for a rehearing or reconsideration?
I know that he had and I apologize, I wasn't handling the case at that time. I know he had the opportunity to go before the court. I don't know specifically if that occurred.
I was going to say, at least our review doesn't indicate such.
Right, we'll go back
But
and
I
check.
just, we'll have to check.
And, Your Honor, presumably he did, because he would have been required to exhaust his remedy before the medical board before filing a judicial review action, with one exception, if the board made the order immediately effective. And I can certainly look to that.
At least in the order that was signed by Lisa Wynn as the executive director, you did get that notice that it's required to preserve any rights to appeal the Superior Court, and Judge McClellan didn't raise that as an issue, and he's want to look at those opportunities. So I'm presuming that it was in fact done appropriately. The board had the information, but I don't remember seeing the request for review and what may have been articulated, because that may be helpful.
And, Your Honor, I do believe that is what happened here, because looking at the order, it wasn't made immediately effective, so there was the right for to petition for rehearing or review. I recall now, in looking at Judge McClennan's order, that and also the opening brief in this case, that the record, a part of the record on review, was inadvertently not filed with Superior Court, meaning that portion of the board's record that would have shown the petition for rehearing or review. And so I believe that's what caused a little bit of confusion here, but that did occur because Dr. O'Connor was able to exercise his appeal rights through the Superior Court.
And if he couldn't have done it there, he wouldn't be here.
Correct. Thank you.
Thank you. Mr. John?
Thank you. Yes, and just to clarify on the petition for rehearing or review, I think it was in the answering brief that the state acknowledged its failure to lodge that document. So that was done. It was, we went, as a matter of fact, it was, I believe, February 2nd of 2012 that we appeared before the medical board. I would just like...
Is the petition then in the administrative record that was presented to the Superior Court, and thus that we have?
Apparently it was not to the Superior Court, but I understood the state then filed it, so it would be with the record that you have now.
Okay.
And I'm presuming that some of the arguments, that the factual arguments that you have presented are outlined in the petition for review or rehearing. Okay.
That would be correct.
Okay.
I'd just like to point out a few other things that I think are just absolutely incredible in terms of a swearing contest, he said, she said situation, and nothing is discussed about it. Patient TM testified in her December 2009 office visit. Dr. O'Connor pulled on her pants and began to conduct an unnecessary pelvic exam. The female chaperone was very upset at that and ran out of the room looking to find Mrs. O'Connor, who was the office nurse. The chaperone, Mrs. O'Connor, and the other female in the office testified at the hearing that event never occurred. Yet the ALJ and the board can't seem to think it's important enough to say, well, why do we believe her if we've got 3 people, professionals who were there, all say it never happened? Then she also contends, patient TM, that of the 5 office visits, she was sexually abused on at least 3 or 4 of them. She testified that on none of the occasions did she ever tell Dr. O'Connor to stop. She did not alert or complain to any of the female office workers. She did not get up and leave, and she continued to return for follow-up visits, apparently knowing she would be sexually abused. Dr. O'Connor clearly testified these alleged events of sexual abuse never occurred. Here is, I think, also an extremely key point. The only time during her office visits when she was alone with Dr. O'Connor was for a very short period of time at the end of the office visit on April 20th. These other 3 or 4 times when she alleged sexual abuse, she was not alone with him. So someone else would have had to witness that. The office staff people testified those things did not happen, yet the ALJ and the board don't consider that significant enough to even discuss. Then we presented the point that what we really have here are these 3 main complainants are troubled people, unfortunately. We presented psychiatric testimony. TM, for example, she was under psychiatric care for 10 years. She carried a diagnosis of borderline personality disorder. According to the testimony of Dr. Patino, the psychiatric expert, this diagnosis is characterized by a patient feeling her doctor is the greatest person in the world one day, and without anything happening, the next day will feel her doctor is evil. That's her condition. Did the ALJ consider that significant enough? He didn't discuss any of the expert testimony. We brought in the polygraph expert because we didn't know when he says, I'm going to do, it's admitted for all purposes. That's when I brought in the expert who said this was done totally unscientifically. And yet, we don't know if the ALJ relied on it. We don't know if the medical board relied on it. They should have said, this is what we relied on, this is why we find credibility. Didn't do any of that. How can you know that this doctor got a full, fair, and impartial hearing? Thank you very much.
Thank you, Mr. Janish. We thank you for the argument. It's been helpful. We will take this matter under advisement and issue our written decision in due course. Until then, we stand adjourned. Thank you.
Well, Ann, hey. You know that I retired, so. Well, this is really sort of my last formal act. Last week we had a mediation in my last case, so I have one medical board investigation going where I'm helping a doctor yet, but that'll be over with soon.
Well, enjoy your retirement.
I hope so. You guys have much trouble finding